welcome to this year's symposium. My name is Anna King, and I am the symposium editor at the WMU Cooley Law Review. And just before we get started, I just wanted to take just a second to really thank our panelists and the moderator for their generosity in volunteering their time and energy, agreeing to participate in the symposium. There are a few behind the scenes people also who deserve some recognition and thanks. They are the Law Review board members, as well as Professor Christy Hinkey, the symposium team, Marcus Douglas and Mercedes Mark, and a very, very special thank you to Terry Corella, Audra Foster, and Professor Mark Cooney, who they just possess an amazing human characteristic of committing 100% to making someone else's idea or vision become reality. So thank you. Without this entire group, the symposium would not be possible. So thank you all so much for agreeing to do this. And then Professor McDaniel, I think everybody needs to know who you are. Like, I have to introduce you, and I also have to say that, you know, I really had to narrow down what I would say about Professor McDaniel, because we could spend this entire symposium entirely on his accomplishments. Plus, with the panelists' accomplishments, we really could spend the whole time here. So I'm going to shorten this anymore because I know we're already 10 minutes in, but our moderator this evening is retired Brigadier General Michael McDaniel, who before becoming a Brigadier General was a military judge for 27 years. And he also went on to work at the Pentagon as the former Deputy Assistant Secretary for Homeland Defense, Strategy, Prevention, and Mission Assurance. Currently, he is a professor of constitutional law and the director of the Homeland Law LLM program at WMU Cooley Law School. So thank you, Professor McDaniel, and I look forward to this symposium. I've been waiting for this. It's going to be great.
Well, thank you, Anna. And again, I want to thank all our panelists as well. And welcome everyone out there. This is fantastic that we're having this. And I will say, it is often said that we've just have an esteemed and established panel here. But when you understand the accomplishments of our 5 panelists today, it will be very clear that we couldn't create a better panel for this issue. They are all right there on the cutting edge of these issues. And when I say these issues, what are we talking about? Well, social media companies are sort of taken for granted now, but back in 1996, when the internet was in its youth, it wasn't so certain that this was going to be the booming medium, the predominant media that we have out there. And you look at the fact that 100% of Americans, those in the United States, I should say, are involved on the internet in some way. Statistics say 69% are on Facebook and 81% use the Googler, as my parents would say, even in their 90s, that they were using it, with lesser percentages, but still substantial proportions of individuals in the United States using other social media such as Instagram, Twitter, Snapchat, which all of our students are certainly aware, as I know from talking about the First Amendment and con law too. So we've always had some issues there, and these companies had the Communications Decency Act to sort of provide some protection, some immunity. And for quite a while, we were dealing with issues such as violence and pornography / obscenity, and where those terms of service would protect these companies, and where the Communications Decency Act would fall into the gaps. But with the presidential elections in 2016 and 2020, the issues that social media face grew exponentially as the political debate grew online, and somehow violence came back around from some of that political debate as well. So there is a lot of discussion now in the courts involving these very issues, as well as, of course, in terms of how attorneys such as those that we have here today represent their clients on these issues to, assure that they don't step into some litigious swamp along the way. So our panelists are going to take us through these issues for the next 90 to 100 minutes, and they're going to do so in just bracing fashion, and I'm looking forward to it. So I want to first introduce you to Jesse Panuccio. It's easy, really two things I have to say about him. First, he's with Boys, Schiller and Flexner, which if you pay attention to anything inside the Beltway, that's one of the largest, most predominant firms in Washington, D.C. David Boyce came to national attention in a number of cases, including Bush v. Gore, which we certainly still talk about in con law. And so a great super firm. And before that, Jesse was he was number 3 at the DOJ. He was the acting associate attorney general at the DOJ. And in that role, he oversaw the civil and criminal work for antitrust, civil division, civil rights division, environmental, natural resources, and tax divisions. So just about the entire civil side of the DOJ was under Jesse's aegis. And during that office, they were involved in some pretty significant litigation, including some large financial institutions, healthcare companies, automakers, energy, and state and local governments. He was also the chair of the DOJ's Regulatory Reform Task Force and vice chair of the DOJ's Task Force on Market Integrity and Consumer Fraud. He has consistently and regularly provided legal and strategic advice to high-level decision makers in the federal government, including the Attorney General and the Deputy Attorney General, as well as general counsels across all the large spectrum of executive branch agencies, as well as White House officials. Now he is engaged in sort of suing the federal government as well as necessary, representing states, representing their regulatory agencies, and on also navigating those regulatory agencies on behalf of those clients. So I asked Mr. Panuccio to start off to give us sort of an overview of how we got here, if you will, with the sort of the emergence of social media that I just alluded to, and then the attendant First Amendment issues that have arisen. Mr. Panuccio?
Well, thank you, General McDonough. Thank you to the Cooley Law School Law Review and to everyone here today. It's a privilege to join you in this community and to be among these distinguished panelists. As you heard, I didn't know I was going to go first, so we'll see if this is truly an overview for everybody. But I think it will be a little different in that as I was preparing for this, I know, especially with this panel, we're going to get into some finer details of social media and law, specifically how the First Amendment applies, the Communications Decency Act, and some other breaking questions. So I actually wanted to step back from that a little bit and talk about the relationship between social media and First Amendment values. So we all know the law of the First Amendment and what it requires and then how that applies. But the First Amendment's inclusion in our Constitution represents a foundational judgment that the ends it secures, free speech, free press, free association, among others, are of paramount importance to society. And so I think a critical question to ask as we think about the First Amendment and social media, the title of this symposium, is whether social media is advancing or harming First Amendment ends and First Amendment values. I think it really can't be disputed that social media has given us more speech, more press, and more ways and opportunities to associate. The internet and social media have us teeming with speech, and the smartphones we all carry around every day ensure that this speech flows and washes over us like a river that we cannot escape virtually any second of the day. So is this good or is this bad? Does this present a historic shift, one that requires radically new ways of thinking about free speech and press, or have we seen this before? I think a good case study here is the core speech that the First Amendment was meant to protect, and that's political speech. If you go back historically, the drafting and the enactment of the First Amendment was really geared toward political speech. And to my mind, American politics has always adapted to and incorporated new forms of mass communication, ever expanding the reach and prevalence of political speech. So in the late 1800s and the early 1900s, newsboys with cries of extra, extra would hawk morning and evening newspapers, and they teemed with political news. When radio emerged, President Calvin Coolidge in 1923 took to the airwaves to address Americans and then regularly used radio thereafter. And Franklin Roosevelt later delivered his famous fireside chats via radio. When television emerged, Nixon and Kennedy had the first televised presidential debate, forever changing how politicians communicated with and appealed to mass American audiences. So politics has always followed an expressive medium as it emerged and expanded, and the medium shaped politics, and politics shaped the new medium. So I think none of this is novel for social media or necessarily requires a new way of thinking about the First Amendment, about First Amendment values or First Amendment law. Now, of course, some of this flood of political speech over social media is ill-considered, it's hot-tempered. As you heard in the opening here in 2016 and 2020, this really came to the fore. Some of the speech is derogatory, it is regrettable, and that has caused some people to claim, I think, that social media is coarsening our politics, making it worse and different than, say, the days of Tip O'Neill and Ronald Reagan, or Jack Kennedy, or Teddy Roosevelt, or pick your, whatever your utopian moment was for American politics. Today is supposedly worse, and it's worse because of, in part, social media and how coarse it has made the conversation. But to my mind, these arguments betray an ignorance of our history. Coarse political speech is nothing new for Americans. It is, for better or worse, our birthright. From our founding, we have been a people who boil over with political speech and coarse political speech. If you don't believe me, go read issues of the colonial America's influential and widely circulated publication, Ben Franklin's Poor Richard's Almanac. You'll find plenty of pointed and very sordid political speech. As Professor Akhil Marr at Yale aptly described founding era speech in America, he said, quote, "The Constitution was born in a land awash with speech, and through a process that teemed with talk of the freest sort, including lots of talk harshly critical of existing officials and institutions." So, end quote from Amar, this is now me again. That cacophonous tumult of political speech has persisted ever since. You can go read the articles from the yellow press of the early 20th century, which Teddy Roosevelt complained, and this is a quote from him, "habitually and continually and as a matter of business, practice every form of mendacity known to man, from suppression of the truth and the suggestion of the false to the lie direct," end quote. For those of you wanting a modern day translation of Teddy Roosevelt there, he was saying in longer form, fake news about the press of his day. Or you can go look at any presidential campaign and see what the warring factions said against each other. As early as 1800, the Jefferson camp called Adams a hideous hermaphroditical character which has neither the force or firmness of a man nor the gentleness and sensibility of a woman. Adams, for his part, was no better. He called his rival Hamilton the bastard brat of a Scottish peddler. And Andrew Jackson's mother was called, unfortunately, a common prostitute. Franklin Pierce in 1855 was called the pimp of the White House, and Lincoln was insulted as sooty and scoundrelly and compared to the person who emptied the privies in the evening. And so on ever since. So there was, in short, never an era of good manners in American politics and political speech. So while I don't personally endorse the coarseness reflected in our social media political speech, I think it is, from a historical perspective, nothing new and nothing to worry about, and nothing that requires new law. Moreover, if you view access to and the ability to engage in political speech as valuable, then social media is a huge boon for First Amendment values. It has democratized political speech, press, and association in substantial and historically unprecedented ways. The elite institutions that long had the largest megaphones, traditional media outlets, universities, corporations, political parties, are no longer as firmly in control as they once were of the societal narrative. And this is where I think things get really interesting, to bring it back to present. As social media has created a speech explosion among the masses, the more elite institutions of society, I think, are losing their reverence for and their position as traditional defenders of First Amendment values, and especially free speech. The two places where this can be seen most easily are in the traditional media and in the academy. Just look, for example, at the New York Times of New York Times versus Sullivan, for goodness sakes, or any American college campus, which was once the key defender of academic freedom and free thought and the ability to pursue any idea you wanted with full protections. My own view is that free speech is no longer in vogue in these places. Speech codes and certain patterns of thought are enforced, and First Amendment values matter only if certain speech and certain press and certain association is being advanced. I find this frightening, but I also find it fascinating. These institutions, as I said, long had a monopoly on the fullest exercise of the rights and the values that the First Amendment secured. But with the rise of social media, they are being displaced and their power along with it. So is it a coincidence then that their reverence for First Amendment is waning? Is it a coincidence that they are striking back and seeking to censor and restrict the many voices and the mass voices that have emerged through social media? And is it now a coincidence, now that these social media companies have matured from, as we heard in the introduction, sort of the upstarts of the 90s to large mega corporations of the 2020s? Is it any wonder, is it a coincidence that those institutions themselves now have become elite and are starting to censor the speech on their own platforms? I think these are big questions worth a lot of consideration. And as that now changes, as those social media companies change from upstarts to their own hugely powerful institutions and begin to censor speech, should that change how we think about the law governing those institutions and how the First Amendment interacts with them and their First Amendment rights versus their users' First Amendment rights? There's a lot more to say on that, but I think I have probably used my allotment of minutes. So I'm going to stop there, and I'll be able to react to others. But I hope you at least enjoyed the historical foray into some of the awful things our predecessors used to say about each other in political discourse. Thanks very much.
Thank you, Mr. Panuccio. Next, I want to introduce you to Abby Corbett. Ms. Corbett is a shareholder in the litigation department of Stearns, Weaver, and Miller in Miami, Florida. She has a national legal practice which encompasses a wide variety of complex commercial litigation matters, including defending and prosecuting class actions in both federal and state courts. Abby also regularly advises local governments, as well as other public and private entities, on constitutional law and other governmental affairs issues, including First Amendment issues. So I would ask Ms. Corbett to talk to us about that. Tell us about your practice in advising governmental entities and elected officials, specifically on whether and how they can regulate public engagement on their official or campaign social media pages. We're all aware of, to some degree, the Knight Institute Trump case, and I'm going to ask another one of our panelists about that as well, which involved the president blocking critics what was deemed to be his official Twitter account while in office. Certainly that may not work, but how do public employees or public officials sort of distinguish between the two? And how can maybe a subordinate public employee have their own speech limited on social media under the First Amendment's Pickering Conic test? If you could talk to those issues, it would be very gratifying for us in the audience.
Definitely. Hello, everyone. Good to see you all. So yeah, the interplay between the First Amendment and social media has cropped up in my practice a lot in a lot of different areas, primarily in representing local governments, but also for some private clients. And it's sneaky because there's an interplay in a lot of different ways, depending on the context. For the reason Jesse was explaining, which is there's so many ways in which this is our primary form of speech these days, it seems. So one of the most common issues that I have crop up is local governments that are trying to figure out how to regulate the public's comments or post on official pages, official county, city pages, police department pages. These are public pages, but to the extent there has either proactively or just by default been a public forum created by allowing commenting, or even allowing posting, that's more rare, but by allowing commenting on posts made on these official pages, these local governments have likely opened a public forum, a digital town hall, the equivalent of saying, all right, who wants to comment on this? Now, a lot of times my clients will say, well, our page is government speech. We get to regulate it however we want. And that's true with respect to their posts in large part. But what we're talking about now is the comments, or any way in which you've opened up to the public their ability to comment on your public page, on your official page. And so what comes up a lot is I'll have clients, probably the most common thing is we have an elected official or we have a city or county manager who doesn't like a comment somebody put on a post. That's by far the most common issue. And it's usually that it's negative. It's not obscene, it's not libelous, but it's, maybe derogatory. Can we delete that comment? That question comes up a lot. And I say, you opened this topic as a public forum. You cannot go in and take out content-based, if that's all that's going on here, and these situations are super fact specific, but if all that's going on here is a person put one post, something negative, and you don't like it, no, you are definitely exposing yourself to First Amendment liability by jumping in there and deleting that comment. I get some clever clients saying, well, can we just remove all comments on that post retroactively because we don't like one of them? I'm like, well, that's a little more clever, but you're still doing it for this purpose. So maybe your exposure goes down a little bit, but still problematic. The other question I get is, well, what about just not allowing comments at all? And to the extent that's consistently applied, I think that can be a best practice in a lot of situations. You don't have to. You think about Facebook as being an example. You can disable comments on posts, and then you don't have to deal with this issue. So that's one way, or they cannot have a social media account at all. That's another way to not have to deal with this if they don't want to deal with negative comments. There are also ways of restricting, if somebody comes on a page and is just blasting all caps, flooding a page with noise, right? The equivalent of standing up in a city commission meeting and just screaming. It's like, no, you get your 15 minutes, you have to get your card, you have to wait till it's time. So by analogy, there are situations where someone's abusing the right to comment. And that's also kind of a murky situation, but one that we can usually talk through with clients. Blocking users altogether is super problematic because that's essentially a prior restraint on not allowing them to participate in other commenting either. And so that was what happened in the Knight Institute versus Trump case that Professor McDaniel mentioned. Second Circuit in 2018 said that so it was a really interesting case because it was former President Trump's personal Twitter page. It had been his personal Twitter page. But the government essentially conceded that the posts that were being made on there were being made in his official capacity, and they were official statements of the president. And he had, in fact, allowed commenting on those. But he was removing and then blocking, or he or somebody acting on his behalf was removing and blocking people who were putting negative comments. So it was definitely content-based, and they were being proactively prevented. And the Second Circuit said, the holding is, quote, by blocking the individual plaintiffs and preventing them from viewing, retweeting, replying to, and liking his tweets, the president excluded the individual plaintiffs from a public forum, something the First Amendment prohibits, end quote. So that's the equivalent of saying, let's have a town hall meeting, come here and comment. Oh, when you stood up, I didn't like your comment. You're kicked out of this and all future town halls. And so that really wasn't a close call. Now, it would have been a much closer call if there hadn't been this essential concession that it was an official page. If it had been his personal page, that would have, or personal post, that of course would be very different. But this is while he was acting as president. In fact, those tweets are in the Library of Congress as official statements of the president, along with Lincoln's addresses and everything else. So the one thing I definitely advise clients on in terms of regulating content and comments on their own official pages is have a well-vetted written social media content guidelines document that indicates and you can't be specific about every possible situation, but I've drafted some of these. There are other good ones floating around that other lawyers have drafted. So there's a way to deal with this. Also, it's really good to have more than one social media designee, but only a couple people who are in charge of removing things. So you don't have just anyone getting a call from the city council member and going in there and deleting something somebody doesn't like. You should have a protocol for this. And of course, loop in counsel when it's a close call. So that's official pages by the governmental agency or local government. Another thing that comes up a lot is how can we, as a public employer, regulate private posts made by public employees that we don't like? So the government. Well, let me start with this Pickering Conic balancing analysis that Professor McDaniel mentioned. So this is predates social media. The Pickering case was from 1968. The Conic versus Myers case is 1983, but it still applies here in many situations. The essential idea is that if you're a public employee and you talk about something that is not a matter of public concern and your employer doesn't like it, so you say you're gossiping about somebody in the office or you're complaining about somebody, but it's internal politics, nothing the public really cares about, there's really no First Amendment protection there, because if you get fired by your employer, they're not really firing you and restricting your speech about a matter of public concern. However, if you're a public employee and you make a public comment about a matter of public concern, something people need to hear about or might want to hear about, then there's a balancing test. The First Amendment might restrict your ability to be punished or fired for that. And the balance is, on the one hand, the rights of the employee, and on the other hand, the right of the public employer in having an efficient, disruption-free workplace. Now, the thing a lot of people don't talk about, and some of the cases talk about, but they really should all talk about, is there's actually another factor over here. It's not just the right of the employee to talk, it's the right of the public to hear. And there are lines through certain First Amendment case law where people will recognize that speech isn't just about me talking, it's about the benefit to the common, to democracy really, of other people hearing the ideas when they relate to something that's a matter of public concern. So there's that balancing. And I'll give you an example of where it came up in the social media context recently. Federal court in Tennessee in 2019, there was an interesting case, Goza versus Memphis Light, Gas, and Water Division. And there was a technician at this public utility who had made racially offensive Facebook post related to the Confederate statute in Charlottesville, Virginia. And he was fired, but he actually won his job back, saying that the termination, the federal court held that the termination violated his First Amendment rights. However, that's because the Memphis Light, Gas, and Water Division failed to present evidence that there had been workplace disruption. And I think it was either sloppy lawyering, it's not really clear, or it might have been that it just, word about this post really didn't get around. So there really wasn't an impact on the internal operations of what was happening there. So there just wasn't evidence proffered. However, an example where such evidence was proffered in the education context is a case, 2018 case from the Georgia Supreme Court, Tucker versus Atwater, where a teacher at a Georgia public school received a 5-day suspension for Facebook posts that were critical of Black Lives Matter. And to be clear, all this stuff we're talking about now is on people's personal pages, right? They're not going on the public school's website and posting for the school. They're either posting it on their own page or they're commenting on someone else's page, but in their personal capacity. She was critical of Black Lives Matter. And in that case, her suspension was upheld because the school officials were able to demonstrate that her post, quote, interfered with the operation of the middle school where she taught. So they saw that teachers and other staff members and maybe even students, I'm not sure, saw these posts and were disturbed by them, and there was some disruption. So it's not your normal balancing. You know, when the government comes in to a regular individual, they can't just stop you from talking because it's disruptive, right? But we're talking in this context, very important to distinguish. We're talking about when the government is your employer. Okay, so they're sort of serving two roles. They're serving the role really as an employer, and then the question is, are they also regulating important speech? There's also a little bit of a different standard applied for law enforcement, first responders. In this context, when that balancing is done, there's a recognition by courts that law enforcement employers, police departments, fire departments, have a heightened interest in maintaining discipline and harmony. So a lot of times you'll see Professor McDaniel might tell us whether something similar with the military. I'm not sure. Imagine it's a whole nother world. It's a whole nother application of speech rights when you're talking about military. But for domestic law enforcement, there is some weight placed on that concept that it's just easier to prove disruption if you've got a police officer or police chief. And if I had more time, I'd walk you through examples of, where a police chief criticizes a mayor publicly in a case that might be a close call, which, by the way, in First Amendment litigation, everything's a close call. It's always drawing a line in the smoke. In those situations, they'll err on the side of allowing the local government or the law enforcement agency to restrict the speech when it might go the other way in a different context. Another aspect of my practice is advising elected officials on where the line is with respect to their own, sort of like the Trump situation, where you are a city council member, county commissioner, you name it, and you're currently in office, and this happens all the time, where they use their personal account for official posts or their campaign account for official posts. But of course, they'll also use their official account for personal posts about their mom or whatever. Like there's very little consistency on this. And of course, I advise them to be consistent, but it doesn't happen in the real world. Didn't even happen at the presidential level. So you will have people who are now the mayor will post, right next to like, happy birthday to my wife. The next post will be, I'm thinking about voting on this. What do you guys think? And that particular post, even if the page as a whole might not be your official page, that starts to look a lot like you've opened a public forum to discuss a matter of public concern in your official capacity as mayor, arguably. So if you're going to do that, and then you're going to get mad and you're going to block people, or you have blocked people in the past for other things, maybe because they were a jerk to you or you don't like them, then the question becomes, are you blocking them for the content of their speech? Are you prior restraining their ability to participate? Or it's really best just to have your official page and talk through your official page and make sure you're not restricting speech based on the content that you don't like. If it's obscene or something like that. And that comes up a lot too, that distinction. Well, what about if they're cursing, like what about, versus like pornography, that line gets really murky. And a lot of times local governments or officials just draw the line where they feel most comfortable, even though there might be some litigation risk wherever they draw that line. And then lastly, and I think other people are going to talk about this too, but I, my firm, have been involved in some cases involving the social media companies themselves. Like Jesse and Professor McDaniel were talking about, there's some efforts now to see whether or not the social media companies themselves should be regulated in one of two ways. So first, former President Trump sued Twitter, Facebook, and YouTube in the Southern District of Florida. These cases were transferred under Forum Selection Clause out to the Northern District of California. The Twitter one was just dismissed a couple months ago, but it looks like Trump's lawyers are appealing to the Ninth Circuit. But what that case does, those cases do, is, as you all know, first of all, if we want to back up really far, the First Amendment says Congress shall make no law abridging the freedom of speech, right? And that's been extended to the states under incorporation principles, and obviously it applies to just the government in general now at the various levels and not just Congress. But it's never applied to private actors, right? Private actors are not implicated by the First Amendment, period, with the following extremely narrow exception, and it's really not even an exception, but there are situations in which private actors can be co-opted by the government to be acting as state actors. And the theory behind President Trump's cases against those online platforms is that they were acting as state actors because they were forced by the government to deplatform him. Now, he was president of the executive branch at the time, so he's really not talking about the executive branch. He's saying that that Congress forced them to, but not necessarily through legislation, more about like through speeches and threats of potential future legislation. So, and that case also involved a challenge to Section 230, the constitutionality of it, which I think someone's going to talk about in a little bit. But anyway, so that case is an example of where the First Amendment is trying to be applied to social media companies themselves as if they were state actors. A little bit of a stretch, but who knows, there may be situations in which that actually they are co-opted. I mean, it's theoretically possible. It doesn't seem like the facts are there on that one. But and then lastly, one thing I wanted to talk about is there's a couple new statutes, one in my home state of Florida that my firm was involved in bringing litigation against the state of Florida pretty much right after former President Trump was deplatformed. Governor Desantis signed the Stop Social Media Censorship Act. And it did a couple of different things, but one of the things it did is impose fines on social media platforms, at least the bigger ones. It didn't apply to small ones, but $250,000 per day if you ban a candidate for statewide office in Florida. If you deplatform them, you get fined per day. So the district court and then now the 11th Circuit Court of Appeals held that that statute was unconstitutional under the First Amendment rights of the social media, sorry, the social media companies themselves, because it's speech. Wasn't just First Amendment, by the way, equal protection. There were other causes of action, but the idea being that these companies have the right to, just like a, the New York Times has a right to run whatever article. I'm not saying that's a perfect analogy, and we can debate that, but that's the concept, is that this is their First Amendment rights, and if you punish them for kicking somebody off their platform, you're infringing on their First Amendment rights. But like Jesse said, there's also questions about, the First Amendment rights and the counter argument to that is, what about the First Amendment rights of the people being deplatformed, or the people who want to hear from the person who's deplatformed? The problem is, of course, that the First Amendment is not implicated unless we're talking about a government actor. But that's the First Amendment. I mean, I think another really interesting line of statutes and debate is tort law and statutes like Section 230 that we're going to hear more about, because those companies can be regulated, and if they're engaging in deceptive practices or they're otherwise interfering with people's and in fact there was a deceptive unfair trade practices and claim in Trump's cases against those social media platforms. So that's kind of a different animal, because those kinds of statutes do apply to private companies. So I'm going to stop talking now because there's so many other people I want to hear from, but I'm happy to answer questions later if anybody wants.
Thank you, Abby. Yes, you raised a lot of the issues. Gave us a nice overview of some of the issues that we want to talk about tonight, including, of course, the Trump's Twitter platform. So it makes perfect sense for me to now introduce Ms. Stephanie Krent. Ms. Krent is a staff attorney at the Knight First Amendment Institute, where she focuses on government transparency, surveillance in the federal prison system, and social media censorship. She's a core member of the team seeking the disclosure of secret Office of Legal Counsel opinions in 2 lawsuits, the Campaign for Accountability versus Department of DOJ and Francis versus the DOJ. She recently co-authored an op-ed in the Columbia Journalism Review on the importance of pushing against the Office of Legal Counsel's pervading secrecy in order to inform journalists, historians, and the public at large. As I mentioned, she's also involved in Knight Institute's litigation, seeking records concerning the Bureau of Prisons' digitalization, retention, and surveillance of mail sent to people incarcerated in federal prisons. Prior to joining the Institute, Ms. Krent clerked for Judge Edgardo Ramos of the U.S. District Court for the Southern District of New York and Judge Julio Fuentes of the U.S. Court of Appeals for the Third Circuit. She's a graduate of Barnard College and Yale Law School. Received the Harlan Fiske Stone Prize for Best Argument in Moot Court and the Potter Stewart Prize for Oral and Written Advocacy, and was the comments editor on the Yale Law Journal. So, Ms. Krent, lots to talk about there, perhaps starting with your institute's suit against President Trump that was just raised by Ms. Corbett. And then also, that case was the Supreme Court decided the case was moot. But do you think another social media blocking case is heading to the Supreme Court soon? And I guess sort of the other side of what Ms. Corbett raised, well, what actions can public officials take against comments online without violating the First Amendment? And then I suppose what I'm really thinking about on the other side is what individuals whose comments are deleted or hidden by a social media company, what recourse might they have against the company or against the public official? So given your broad panoply of issues there to talk about, but focusing in a little bit more on some of those that we've raised so far, please.
Yeah, thanks so much, General McDaniel. It's really great to be here, especially with all of you. I'm really excited by the opportunity to come talk to you all about some of the Institute's cases involving social media use by government officials. And obviously, as Abby mentioned, and as General McDaniel mentioned, our most well-known case is probably Knight First Amendment Institute v. Trump. And that's the case in which we sued on behalf of, some individual tweeters as well as ourselves against President Trump for blocking critics on Twitter. It's kind of hard to imagine at this point, especially since, as General McDaniel mentioned, that case only came to an end last year in 2021, but we're approaching the 5-year anniversary of when that complaint was filed. And so it's kind of a really nice time to think about where the doctrine has moved since that time. I mean, at the time we filed the case, this area of law was very unsettled and very new. And right now, courts in really almost every circuit in this country have kind of accepted the general principle that we were fighting for in that case and that other early social media blocking cases were all about, right? And that's kind of the central principle that Abby mentioned, which is that official use of social media can implicate the First Amendment. And specifically, when you have a public official that's opening, what courts have called an interactive space and what we all would probably better know as a comment thread, that when public officials are opening those comment threads for every member of the public to come and talk, those comment threads become digital public forums, and people are entitled to their full First Amendment protections when they're participating in those forums. Another thing courts have recognized that I think was not so clear 5 years ago is that being banned or blocked from one of these accounts, having your comment hidden or deleted, those are really serious First Amendment harms to the person who wants to speak, but they're also really damaging to the free speech ecosystem as a whole, right? And those are injuries that courts now take really seriously. But what I wanted to do kind of with the remaining time I have today is focus on some issues that I think have been less well settled by courts and issues that I think are coming up in, kind of the second wave of social media blocking cases that we're seeing today. So the first issue is something that Abby talked about, which is kind of when an account is subject to the First Amendment at all, right? Like some instances are going to be extremely clear. You have for example, I don't know, the Michigan Secretary of State's office Facebook page, and it'll have a blue check mark to show that it's a verified government organization. The website associated with that page will go directly to the, michigan.gov website. There's going to be a .gov email address as the contact information, and all of the posts will be about, official policies that the Secretary of State's office is putting out. That, I think, is very clearly an official account, and that tips over into kind of state action, right? Where the office or the account holder's actions are going to be fairly attributable to Michigan and to that executive body. But there are other cases, right, that are maybe equally as obvious on the other side. Like maybe you have a legislator who had a long-running kind of personal Instagram account, and that Instagram account is private. It's not open to the public. Maybe there are a dozen or so friends, and all this legislator does is post pictures of her dog, right? I think that's pretty clearly not state action. And any conduct that that legislator takes on that account is probably not going to fall within the protections of the First Amendment. But there's a whole universe in between those two poles. And courts have had, I think, the unenviable task of sifting through some of these more challenging cases that are kind of on the fence. Our case against President Trump wasn't such a slam dunk at the beginning because we did have to contend with the fact that that was a personal account that predated his time in office. We had very strong evidence that once he entered office, he began using it as an official arm of the state. It helped that, he referred to his tweets as official policy. I think that helped courts feel pretty comfortable with that case. But we've seen courts kind of work out the differences between campaign accounts and official accounts, personal accounts and official accounts. Some courts have kind of questioned what to do with accounts of legislators because they may not have the same role that an executive branch official has in kind of setting policy directly, right? They're part of a deliberative body. And so courts have said, well, should we apply the same rules to them that we might apply to executive officials? So far, though, I was going to say all, but I really should say most courts have applied kind of this holistic, fact-intensive look at what the account looks like, how it's being used. But just last month, the Sixth Circuit kind of threw a wrench in this. So they issued a case called Link DV Freed. And in that case, they took a much narrower view of when an account is going to be subject to the restrictions of the First Amendment. And, I don't want to get into the specific kind of 4-factor test that they laid out, but the key difference is that what they look to is kind of formal signs from the state that this account, was maybe used on state property, that state money was going to the account, that state employees were being used to manage the account. So it takes a much more formalistic view of when an account is subject to the First Amendment, as opposed to kind of the functional test that other circuits had been developing. And I think that kind of should issue maybe a warning sign to all of us about the ways in which this doctrine could still change, because that, to me, suggests a really cramped view of the rights that people have on online public spaces, right? It really limits free expression online. And I think that's really dangerous, because in this context, what the state action doctrine should be meant to do is to kind of help protect the free speech rights on both sides. So the rights of people who are truly using an account in a personal way as part of their own personal expression, right? And their desire to create a community and cultivate it of their own choosing, versus the really important rights of the public to be able to participate fully in accounts that actually are being used as official arms of the state, to participate fully, to be able to convince people of their ideas and petition for grievances in what truly are digital public forums. So to me, that's the benefit of the more holistic, kind of fact-intensive and functional test. And we'll have to see, kind of as other circuits kind of continue to weigh these issues, which approach they take. The second issue that I wanted to talk about is, as you said, General McDaniel, like, what can you actually do once you are in one of these digital public forums? What can the account holder do, and what can you say as a member of the public? This question actually has not been fully answered yet, because so many of the early social media cases involved really, frankly, obvious instances of viewpoint discrimination. So in the Trump Twitter case, President Trump admitted that he blocked people because he didn't like what they had to say. Like that was the whole purpose. You had other cases where defendants made similar concessions, or where they kind of offered no justification whatsoever, so courts felt pretty comfortable inferring that what was going on was the suppression of ideas. Now, in more recent cases, you see some government defendants suggesting that the reason for taking an adverse action against a comment or against a commenter really had nothing to do with the viewpoint that was expressed in that comment, but was maybe for some other reason. For example, the profanity that was used in the post, or maybe the post was kind of off the intended topic of what the account holder wanted to discuss. And when we're talking about blocking that's done for reasons that aren't kind of explicitly based on viewpoint, I think there may be some intuitive appeal to the idea that account holders should have more leeway. Like, as Jesse mentioned, like, we've all heard kind of like the comment thread is like, never look at the comments, right? That's where you're going to get the coarse comments. I don't remember now, Jesse, what Teddy Roosevelt said, the mendacious comments. Like, that's where kind of good discourse goes to die. And so you might kind of like envision a world in which you have this moderator who's like helping us be our best selves, right? That's kind of like encouraging this productive conversation, keeping things civil. But as much as I like share that goal, I kind of want to burst everyone's bubble here and say that we should be really wary, and courts should be really wary, even when account holders claim to be blocking speech for non-viewpoint based reasons. And the reason I say that is because all too often, I think these justifications are just kind of papered over versions of the type of blocking that President Trump admitted to. So one of the cases that I'm currently litigating, we represent PETA and other animal rights activists. And they noticed that many of their comments criticizing the National Institutes of Health for their funding of animal testing on NIH pages that were clearly official NIH pages were being hidden. And they wanted to know why, so they filed a FOIA request, and they learned that the NIH had explicitly chosen to automatically suppress any comment containing one of 24 words that are kind of very closely associated with animal advocacy. And when I say closely associated, I mean words like monkey, words like PETA, torture, stop animal testing. So they weren't really being subtle about what type of speech they were hoping to keep off of their page. And we thought the NIH might back down pretty quickly, but what they said is that they were justified in removing these comments because they actually don't talk about animal testing all that much on their page. So any comments bringing up their involvement in animal testing must be off topic. And, you see this in other cases too. There are cases involving people that use profane language or language that some might think are profane and others might not, as part of criticizing the police, criticizing police responses, and criticizing the police's relationship to the community. And those cases have gone, both ways. Some courts have said, this is kind of a backdoor way to suppress ideas and criticism of the police. And some courts have said, a profanity block is really not problematic at all. And it's not what you said, it's how you said it. And so we're not going to get involved. But I hope these examples illustrate the kind of dangers of giving too much leeway to government account holders in this space. And, before I wrap up, I do want to make clear I'm not advocating in favor of a bright line rule that would say like all content moderation on these pages is automatically unconstitutional and that it would always violate the First Amendment. I'm perfectly aware that harassment exists in online spaces, and the unfortunate reality, right, is that much of that harassment is targeted at marginalized communities and representatives of marginalized communities. And I think account holders have a lot of very genuine concerns when they ask, do we have to host hate speech when we know it might drive other people away from this page? Do we have to host speech that, we think of as abusive towards other people? But what I want to make clear is that the answer can't be a simple yes or no. It really has to be, as Abby said, kind of a fact-intensive look at what the account holders' goals are and whether or not they're applying them consistently throughout the forum. So I think I'll pause there for now, but really excited to continue this conversation with all of you later.
Thank you, Stephanie. That was very informative. I want to turn now to Caitlin Vogus. She is the Deputy Director of the Center for Democracy and Technology's Free Expression Project, which works to promote law and policy that supports internet users' expression rights in the United States and around the world. Her work addresses online speech in the First Amendment, Section 230 of the Communications Decency Act, and global intermediary liability regimes, as well as content moderation. Caitlin also focuses on technology company transparency, with an emphasis on researchers' access to data held by hosts of user-generated content. Before joining the CDT, she was a senior staff attorney at the Reporters Committee for Freedom of the Press, where she advocated on behalf of journalists in defense of their First Amendment and newsgathering rights, and she led the Reporters Committee's amicus brief practice. Prior to the Reporters Committee, she was an attorney advisor at the Federal Communications Commission. So, Caitlin, we've talked about a number of issues today, and if you could focus in a little bit more on the issue of deplatforming and perhaps the net choice cases, and if you feel like it, perhaps loop in Section 230 of the Communications Decency Act. I know that I sort of mentioned it in my opening remarks, but I didn't really cover it in detail, and I hope that you would.
Absolutely, General McDaniel, and thank you so much. I'd like to start by just thanking the Cooley Law Review for the opportunity to speak tonight and for assembling such a great panel. It's been wonderful to hear the remarks so far. One of the things Jesse mentioned, I think at the outset of his remarks, is that we should be thinking about the overall question of, is social media harming or promoting First Amendment values and interests? And so what I want to talk about tonight is about how two protections that we often see thought about as special protections for social media platforms, and that is the First Amendment right to engage in content moderation, and then secondly, Section 230 of the CDA, how those protections should actually be thought about really, that they're really important protections for social media users themselves and not just the platforms. The reason that I want to focus on that is because I think that social media users' free expression rights need to be at the center of the conversation when we're thinking about social media and the First Amendment. And as Jesse also pointed out, social media companies have facilitated more speech today than past generations could ever have previously imagined. But social media companies are also criticized a lot for their censorship that they're engaging in through their content moderation policies. And I want to start by acknowledging that social media companies' content moderation is seriously flawed. Moderating content at scale is incredibly difficult. And not only is that the case, but we know that companies often have not devoted sufficient resources or attention to doing content moderation well. A lot of companies rely on automated tools to do their content moderation, and those tools are incredibly blunt. They don't understand the content of speech, and they really don't understand the context of speech. And so that means that they struggle to correctly identify what speech actually violates a platform's policies, and they end up either allowing speech to be posted that shouldn't be posted or removing a lot of speech that shouldn't be removed. And the other thing we know about automated tools is that they reflect the biases of the people who make them. They're not just neutral tools that go out there and function, they're informed by human biases. And what that means is that they often end up over removing content from marginalized groups, whether that's people of color or LGBTQ people or non-English speakers. And that's really detrimental to users' free expression rights. There are also a lot of concerns about conservative censorship on social media. Some people claim that social media companies are biased against conservatives and over remove their speech. And that concern is what's motivated these laws in Florida and Texas, the social media deplatforming laws, that in different ways try to control or put limits on what social media companies can do when they moderate content, and tell social media companies that they cannot remove certain types of content or content for certain reasons that they might want to remove it. Okay, but despite all of these flaws that I've just pointed out when companies engage in content moderation, what I think actually is that if we try to let the government step in and tell companies how they can or cannot engage in content moderation, that actually leaves us all worse off as internet users, and it violates the First Amendment. So many courts have held that social media platforms have a First Amendment right to engage in the exercise of editorial discretion, and that protects their right to moderate content. This is based on cases going back to the 1970s about newspapers. Miami Herald versus Tornillo was a case coming out of a Florida law that gave politicians a right of reply in newspapers. And the Supreme Court struck that down, and they said it violates newspapers' rights to engage in the exercise of editorial discretion. And then in later cases, the Supreme Court kind of expanded on and explained that right more. So another case that gets talked about is the Hurley case, which involved a parade organizer in Boston who was trying to organize a St. Patrick's Day parade. And the organizer did not want to include a pro-LGBTQ float in the parade. The city told him he had to. He fought that and said it violated his First Amendment rights. And the Supreme Court agreed, again, based on this theory about the First Amendment right to make editorial judgments. The court said that running a parade was a way of compiling other people's speech, essentially, and the judgments about who to include and who not to include were an editorial judgment that's protected by the First Amendment. And so too, similarly, I think courts have correctly held that social media companies engage in editorial judgments and decisions when they decide what content they want to host and what content they don't want to host. And most recently, the 11th Circuit held, in the case that Abby mentioned earlier, the Net Choice v. Florida case, that platforms do have this First Amendment right to engage in content moderation based both on this idea of editorial discretion, and also they said that it's inherently expressive conduct when a platform makes a decision about what it wants to host or what not to host. So all of this has been talked about as a right that's held by platforms, platforms' First Amendment right to engage in content moderation. But it's also a really important protection for users, which seems counterintuitive. Why does protecting platforms' First Amendment rights to make decisions to remove speech protect the free expression rights of users? And the reason I think that is because I think that giving the government the power to tell social media companies that they cannot remove certain types of content or must host certain types of content, it removes users' ability to make choices and decisions about which types of platforms best suit their need and where they want to speak online. So most of us are probably on multiple social media platforms. You might be on LinkedIn to try to find your first job out of law school. Maybe you're on Facebook to connect with your grandma. Maybe you're on Ravelry because you really love knitting. And different platforms make different choices about what types of content they want to allow in order to serve their users. So a platform that's focused on professional life or children might have really strict rules about nudity, no nudity on those platforms. But a platform that's a dating app or something for artists to try to share their work with the public or other artists, maybe they have more lax rules about nudity. Or a platform like Ravelry, which is all about knitting, maybe it has a rule that says only knitting related content can be on this platform. And different platforms also make different choices about whether to have rules at all and how strictly to enforce them. So even today, there are some platforms out there that have very few content moderation rules, and people can participate in freewheeling conversations using any type of language and talking about any type of speech they want to, up to a legal limit, I suppose, while other platforms have very strict rules about what you can and can't post. And users, because of this diversity, they can make choices about where they want to participate online. Maybe I'm a user that decides I really am excited about having a conversation without any limits or hardly any limits, and so I want to be on a platform with no rules. Maybe I'm a user who decides, actually, I want to have a lot of rules because I'm worried about encountering things like hate speech or being harassed online. And so I want to go to a platform that has stronger rules and enforces them more strongly. And what I think is that all of this is speech promoting because it lets users choose where they want to participate, and it lets them choose the forum that they're comfortable participating in, and results ultimately in more people using these services and more free expression online. And the thing that protects that choice is the First Amendment right for platforms to engage in content moderation. So that's why I think that First Amendment right should actually be reconceptualized as a right that protects users' free expression. The second aspect is Section 230, a law that is talked about a lot and misunderstood widely. So I'll try to break it down in the simplest terms. Section 230, the basic immunity provisions that get talked about a lot, they shield an online intermediary like a social media company from being treated under the law as a publisher or speaker of content that's authored by a third party. And Section 230 also shields intermediaries from liability for actions that they take to restrict the availability of obscene, violent, or otherwise objectionable content. So what does that mean? Say, for example, that Anna posts something defamatory about Bob on Facebook. Under Section 230, Bob can sue Anna for the defamatory post, but he can't sue Facebook. Facebook is immune under Section 230. And if Facebook decides to take down Anna's post, it also means that Anna can't sue Facebook for having removed her speech. So there are some exceptions to 230 immunity, including for things like intellectual property or federal criminal prosecutions, sex trafficking as well. But in general, it's this liability shield for content that's posted by a third party. This also means that intermediaries are still liable for content that they themselves create. So for example, if Twitter created its own label for a tweet, and that label itself that Twitter created was defamatory, Section 230 would not shield Twitter in that case from liability for its own label that it had written that was defamatory. It could still be held liable under 230. So why did Congress enact Section 230, and how does it protect users' online free expression? It sounds like a pretty great deal for platforms, right? They get all this immunity, but what is in it for internet users? So the first thing is that Section 230 was designed to remove disincentives against online content moderation that traditional publisher liability would create. So because of the way courts had interpreted publisher liability online, the case law before Section 230 was enacted actually made an online platform potentially more liable if they engaged in content moderation than if they just threw up their hands and didn't moderate content at all. And Congress looked at that situation and said, this is not a good situation. We want to encourage intermediaries to engage in content moderation so they can remove speech that is harassing, harming users, preventing users from fully participating online. And Section 230 was designed to do that. On the flip side of things, Section 230 was also designed to ensure that intermediaries don't have an incentive to remove speech that is perfectly legal, to over-remove speech. So the way this works is if an intermediary were worried that it might be held liable for a user's speech, it's going to err on the side of removing that speech. So if an intermediary is worried, for example, that my post is defamatory, it's going to have a really hard time actually figuring out whether my post is defamatory or not. It's going to have to look into things like the truth of my post. What was my state of mind potentially when I posted it? Is the person I'm posting about a public figure or not? And that's extremely complicated. And what an intermediary without Section 230 would probably do is just say, you know what, I'm going to take down that post because I don't want to be legally liable. That means that speech that's important but on controversial topics would be especially vulnerable to this type of over removal. So for example, the Me Too movement, which really got its start through women posting information about sexual harassment that they'd experienced online. All of that is extremely legally risky and potentially defamatory if it's not true. And if platforms were worried about being held liable for that defamation, they may have just removed all of that speech. But Section 230 means that you can't sue the platform for it. If it's defamatory, you can sue the original poster, but not the platform. And so that speech was allowed to remain online. So I guess at base, what I'm trying to say is that even though Section 230 creates immunity for platforms, it's still a really important protection for users, just like the First Amendment protection to engage in content moderation as well. And I hope that as we talk about the other First Amendment issues we're thinking about tonight, transparency and other things as well, we can keep in mind that the user is really what should be at the center of all of this, because what matters most is our free expression rights to both put out speech and receive information online.
Thank you very much, Caitlin. Excellent explanation. I particularly am gratified for your discussion about content moderation and its benefit to users. Frankly, I hadn't thought of that, and I appreciate that. And moving to John Browning, who's been waiting patiently. He is a partner in the Plano, Texas office of Spencer Fain, and he concentrates his practice in civil litigation appeals in state and federal courts. Prior to returning to private practice, he was a justice on Texas' largest appellate court, the Fifth District Court of Appeals in Dallas. Justice Browning is also engaged in the academy. He is a distinguished jurist in residence and professor of law at Faulkner University's Thomas Good Jones School of Law in Montgomery, Alabama. Of special note to all our WMU Cooley students, he is president-elect of Scribes, the American Society of Legal Writers, which the school has been engaged in as well. And as you might guess from being involved in Scribes, he is heavily invested in writing in the legal field. He is the author of 5 books, including The Lawyer's Guide to Social Networking, put out by West in 2010, The Social Media Litigation Practice Guide, West in 2014, and with Professor Jan Jacobowitz, Legal Ethics in Social Media, a practitioner's handbook. Came out by the ABA in 2017, but a second edition is forthcoming this year. He has received many, many awards for his writing, including 4 Burton Awards for Distinguished Achievement in Legal Writing, the Defense Research Institute's G. Duffield Smith Outstanding Publication of the Year Award, the Oklahoma Bar's Golden Quill Award for Best Legal Article, the Texas Bar Foundation's Outstanding Law Reviewed Article Award, and he advised me he just received the ABA's Silver Gavel Award for his writings. And I have to mention, he is heavily engaged in a cause dear to my own heart, actively assisting military veterans. Lots that you can talk about, Justice Browning. And I would ask, given how we have just been galloping through the time so far, I think I'd ask you to discuss 2 things, if you could. If you could talk about the Texas deplatforming law, but then if you could also sort of segue into the next session that I want to talk about, or have our panelists talk about, and that is, where's the law going? And I think the Paxton case, perhaps, where you had 3 justices who would have had the case not be stayed by the Fifth Circuit, and therefore the Texas law would have been could have been enforced by the Texas Attorney General against social media companies, and it's focused in that law on viewpoint discrimination, or so it says, viewpoint discrimination, contrary to what Caitlin just told us. And if you could also, and I'm loading you up here, if you could also sort of talk about Section 230. Many think it needs to be amended. We had a very strong defense of it, but I know that some think it should be amended as well. So if you could take us through those 3 issues, the Texas deplatforming law, and then where you think the Supreme Court might go on that issue, and then perhaps Section 230. And that will also give our other panelists time to think about what their viewpoint is on where the law may be going next in this area. Justice Browning?
Certainly. Thank you very much, General McDaniel. And thank you to everyone at Cooley Law Review for putting on this wonderful symposium. And thank you to my fellow panelists for such fascinating discussion tonight. And I hope I'm not going to bring the quality of the discourse down any. But first of all, to address these, we've had some discussion about the Florida deplatforming law, which is pretty much, as we'd say in Texas, that dog didn't hunt. The 11th Circuit made it very clear that was unconstitutional. The Texas law is still got a little bit of life to it. So the Texas law was allowed to go into effect on May 11th. The tech industry groups immediately brought an accelerated emergency request to the Supreme Court. The Supreme Court, in a 5-4 decision on May 31st, decided to grant an emergency request for stay, pending the appeal to the full Fifth Circuit, the en banc Fifth Circuit, to decide, rather than a panel, the future of Texas's law. So what does the Texas law provide? It is, and it's got some important differences or distinctions, known as House Bill 20. It would allow the state of Texas, as well as individual Texans, to have a cause of action. It's not just an attorney general right of cause of action, to bring suit against tech companies, against social media platforms, provided that they are over a certain size. They have to have more than 50 million users. And obviously that narrows the field. We're talking about the Facebooks, the Twitters, YouTube, Snap. We're also talking about TikTok. I could have done this as a TikTok video, may have been more entertaining, but no one needs to see that, believe me. If you've ever seen me anywhere on a dance floor, no one needs to see that. So that's who it would apply to, and it would apply if these platforms were engaging in viewpoint discrimination by banning them, blocking them, removing their posts, deprioritizing their posts, or otherwise engaging in viewpoint discrimination, as opposed to what we generally, would regard as content moderation. Now, the tech industry, in responding to this, you're allowing private cause of action, you're opening the floodgates of litigation. It's important to keep in mind that this would allow for not damages suits, it allows for declaratory or injunctive relief only. So we're not talking about, this is going to expose these companies to huge damages. It also contains some public disclosure, some notification provisions. States that social media companies would have to publicly disclose how they moderate content, how do they use search, ranking, algorithmic use, which obviously has a lot of resonance, I think, with folks, particularly with what many critics, surveys, whistleblowers such as Frances Haugen from Facebook, an insider view of how Facebook's own policies are contributing to social media addiction among young Americans. So this, and by the way, there are also some other limitations that distinguish it. There's a severability clause, so that if one provision is found unconstitutional, the rest of the statute could survive. There are geographic protections. Does not allow a platform to censor based upon a user's geographic location. So if you have someone who is, let's say, on one coast or the other, saying, oh, they're in that flyover state, we don't need to hear from them. That's not going to be allowed. But that is the Texas law in a nutshell. And I indicated the status of it. So let me and by the way, this should probably be best understood against the larger landscape nationally. We've talked about Florida and Texas, their statutes for obvious reasons. They're the first ones that went into effect. But make no mistake, this is part of a national effort. There are probably, at my last count, about 34 state legislatures that have taken some form of action with regard to reining in social media platforms. Now, these are not all the extreme or reining in what some would call viewpoint discrimination of the Texas and Florida statutes. They're just the first ones that were enacted into law. But there are probably 4 separate categories of these type of bills. More than 24 of them, including not just Texas and Florida, but states like Georgia, Tennessee, Ohio. I think Michigan has a comparable statute or bill that would prevent platforms from censoring content or blocking users. There are other ones which have been more popular in what you might describe as blue states or Democratic-controlled legislatures that are bills that would seek to require social media companies to provide greater mechanisms or protections against hate speech or misinformation, including better mechanisms for reporting this. There are other bills that have been more bipartisan in nature that are protecting children from social media, ones like in California. There are others that, again, enjoy support from both sides of the aisle that would seek to impose greater transparency requirements on it. So this is part of a larger national landscape, which I think is a reflection of a public lack of trust in a number of institutions. Social media platforms have been among those, given what we now know about social media. Let me go out of order a little bit and talk about Section 230, because we've talked about Section 230. It's safe harbor for against civil liabilities, this civil immunity against lawsuits. It's important to understand one big overarching fact about Section 230. And I say this because I've only been practicing law for about 33 years. But Section 230 was enacted before there was an internet, before there were social media platforms. No one could have ever fathomed what we would have now in terms of the Wild West that the internet essentially was / is in many ways. What social media platforms do and are capable of doing. So this idea of fitting social media into Section 230, Section 230 really is woefully under-equipped to address many concerns with regard to social media, and there are many folks on every part of the political spectrum, including some in the tech industry, who say, Section 230 needs to be amended. And I think we're seeing some signs of this in the courts. For example, it was alluded to before about statutes that carve out, for example, human trafficking violations, the extent to which platforms have some level of complicity in human trafficking. We had a major case against Facebook that went all the way to the Texas Supreme Court, and Facebook lost because the anti-human trafficking statute clearly carved out or contained a carve out with respect to Section 230, and so it did take out this this immunity. We've also seen this increasing trend among courts around the country to look at social media as and apps associated with social media companies as a form of product liability. The Ninth Circuit last year in the Lemon versus Snap case said, yes, Snapchat's speed filter that contributed to a horrific auto accident The Georgia Supreme Court, similar decision, said, yes, you can have strict liability because of this product that you put out. We're seeing this in greater frequency of courts to impose that sort of liability, that social media can be a quote unquote product, and there can be exposure for that. So let me talk a little bit about where the law is going. And I think it boils down to, how do we regard social media? Are we going to treat it like a newspaper, and say, yes, obviously they can engage in content moderation. The argument by some, and I will say it's not an argument I share in. I think that, it's pretty clear that both the Texas and the Florida statutes, and I respectfully disagree with my friend, the Attorney General, Ken Paxton. It is clearly a First Amendment violation. Simply, I mean, it's unconstitutional in its current state. But the opposition to, or the folks who are advocating for the Texas and Florida and similar statutes, are not making arguments that are that far-fetched when they say it's not like a newspaper, it's more like a utility. It's like a common carrier. We may not think of Facebook and Twitter like a railroad or a telephone company or something like that, but this argument that they should be operating under the same First Amendment restrictions as these sort of companies, rather than enjoy the First Amendment protections that newspapers do to decide what content is displayed, is not an outrageous one. And I think we can see some hints of where the law might be going, not only in the 3 justices from the conservative wing, the conservative now majority of the Supreme Court, have said, and if this were a boxing match, they're telegraphing their punches. We already know how they feel. They're not trying to hide it. But we can look at a recent decision from 2019, a case of Manhattan Community Access Corporation versus Hallock, and that discussed if a private entity operating a public access channel would be subject to the First Amendment, to the constraints of the First Amendment, as a state actor running a public forum. And in this case, it was a, public access, or operators of a public access TV network that weren't happy that a couple of folks, maybe you might call them, gadflies, made a film that was highly critical of that network, and they wanted it aired on that network, and they didn't, for obvious reasons, didn't want to air it, and they said, we don't have to. And the court, which again was sharply split, ruled that a private entity engaging in quote unquote viewpoint discrimination, even in a public forum, is allowed to do so. Why? It's private entity. It's not a state actor. Now, the opinion does mention this common carrier analogy. So, it's hardly coincidental that this comes up in both the Texas and Florida statutes and their supporters. But, Justice Kavanaugh, in his opinion, said, quote, a private entity who provides a forum for speech is not transformed by that act alone into a state actor. So for now, that has held true, but we have a different court from 2019. We have, some very clear and open statements of opinion. Justice Alito, in particular, has made it clear. Justice Thomas has made it clear as well, where he wants things to go. And Justice Alito even said, it's not obvious how our existing precedents, which predate the age of the internet, should apply. But, let's give Texas a shot and let's hear things out. I think we know, if the full Fifth Circuit decides to give the green light to the Texas statute. Obviously, it's going to be appealed up to the Supreme Court. And this is, I think, as we all know, a Supreme Court that is different in its composition than a few years ago, and that has made it abundantly clear, particularly in recent opinions, that it is, going to flex its muscles. So, with that, I think I'd already addressed the Section 230 part, but I'm looking forward to the rest of our discussion.
Thank you, Justice Browning. Very succinct, and I appreciate that. So we are at 7:30. So I say the rest of our panelists, I want you to sort of either Justice Browning gave us an overview of where the future of social media and First Amendment may travel, or it may not. I would like you to either pick one of those issues or a sub-issue thereof, and I've got to limit you to about 4 minutes apiece to make sure we can get through everybody timely. And I'm going to do it in reverse order, going to you then, Caitlin. And note that Justice Browning did mention the tech transparency issue, which I know is one of the issues that you care about, and this might be the appropriate time to speak on that.
Yeah, absolutely. I think that is going to be one of the emerging issues, and it's a fascinating one because the case law on it is not settled. So I, for one, am excited to see where it goes. So what do we mean when we say tech transparency? So in both the Texas and the Florida law, there are certain transparency requirements that the law imposes on certain social media platforms. So, for example, a requirement to publish a content policy, the rules of the road, what's allowed on your platform and what's not. A requirement in the Florida law, I believe, to tell users if you're going to change those rules. Some of the laws also require, this may be again the Florida law, giving a user detailed notice if they're going to take a deplatforming decision. And so all of this is in the vein of trying to give users and the public more information about what tech platforms are doing. And this is popular not just in Florida and Texas, it's actually something that the US Congress is considering in a lot of bills as well, because there's this feeling, and I think it's a good one, that transparency is very important to allow users to understand the impact of social media on our society, to make choices about where they want to participate online and where they don't, and to help lawmakers understand what's going well and what's going wrong when it comes to social media. But there's a First Amendment question here. Can you compel a private company to disclose this type of information? The First Amendment protects not just against government censorship of speech, but it also protects against the government compelling speech as well. And so in the Texas and Florida cases, NetChoice, representing the tech companies challenging the laws, has argued that these transparency mandates are unconstitutional as well. And interestingly, in the 11th Circuit in the Florida case, the court actually held that most of the transparency mandates are likely constitutional. So requiring publication of a content policy, requiring informing users about changes to rules, the court said that's likely constitutional. The one that they said is likely unconstitutional is requiring a platform to give detailed notice to users about a deplatforming decision. And the standard the court applied is the Zauderer standard, which is a pretty low standard that's about compelled commercial disclosures. And it's meant to apply for disclosures of purely factual and uncontroversial information about kind of the terms under which a service will be available. And the court said this is the right standard to apply, as opposed to a higher standard, intermediate scrutiny, or even strict scrutiny that the platforms were arguing for. And so to some extent, that decision is a blow for the platforms that are arguing that these transparency mandates violate the First Amendment. We'll see what the Fifth Circuit does and what other courts do with these disclosures, but I think that's a really interesting issue to watch and to see ultimately what the Supreme Court does, because in the Texas case, as Justice Browning was saying, the Supreme Court did block the law from going into effect. And it did so in toto, not just the content moderation parts, but also the transparency parts as well. So it's hard to know if the court fully thought that through and just said, we'll block the whole law, and didn't think like maybe the transparency part should be treated differently, or maybe that does indicate what some of the justices at least are thinking about the constitutionality of the transparency parts. So that will be a really interesting issue to watch.
Thank you, Caitlin. And Stephanie, back to you. You mentioned a little bit of where you think the future may go when you referred to the Freed case, the Sixth Circuit case, taking a more formalistic approach than a functional approach. Opportunity to expand on that, or perhaps you also mentioned viewpoint discrimination. And we have certainly with the Texas law, HB 20, we got the idea of viewpoint discrimination flipped on its head, where we've got as Justice Browning said, a private citizen or the attorney general able to bring a lawsuit where they think a social media company is engaged in viewpoint discrimination, albeit as a private citizen. So either those issues or whatever's on your mind, Stephanie.
Yeah, I think flipped on its head is kind of a nice way to describe the Texas bill and its treatment of viewpoint discrimination there. But I think we're likely to see a social media blocking case reach the Supreme Court soon. But I think, as John and Caitlin have said, we're even more likely to see this issue of content moderation reach the court, maybe next term or shortly thereafter, because, these justices are not shy about telegraphing their interest in taking this, right? When the Knight First Amendment Institute case was, GVR'd as moot, Justice Thomas wrote a lengthy concurrence that really wasn't about any of the issues in that case and was instead inviting cases just like the Texas and Florida cases to say, how should we be regulating social media platforms? Who cares about the government officials kind of acting on them? And, I did want to pick up on something Caitlin said, which is that, I think critics and supporters of these bills alike, and I certainly count myself among the critics. I think the majority of these laws are unconstitutional, but they've really been treating the laws with a broad brush, right? Focusing, perhaps rightly, on the content moderation requirements that are put in place because of the kind of transformative effect they would have on these platforms. But both of these laws do have transparency requirements as well, as Caitlin mentioned. And I hope that as, critics are thinking about these laws and courts are thinking about these laws, they do take the time to kind of separate those out, because what we really want to do is focus on, what's best going to serve the free speech ecosystem. And I think when you put that at the center and you put the rights of users to kind of a full panoply of expressive rights online, transparency requirements look a lot different. Now, there might be cases where they can be used as kind of a cudgel against these tech platforms. But I also think in many ways they can be really illustrative, right? They can allow users to do what Caitlin was saying and compare and contrast different platforms' policies to figure out where they want to go and which platforms they want to rely on. So I think focusing on transparency is going to be huge going forward. It's something that Congress is interested in. It's something that lots of states are interested in. And I also wanted to go back to actually the very beginning, which is you, General McDaniel, and I think Jesse also talked about the 2016 and 2020 election and the role that social media played in those elections. And I think the truth is we actually don't have great insight into exactly the role that social media played, how much it may have inflamed or incited different viewpoints. One of the primary reasons that's an open question is because these platforms play it very close to the vest when it comes to their own data, right? They run a ton of studies using data they collect, but they don't let outside researchers have access to that. They really have kind of like a closed lid, and different platforms are different, but by and large, they're very restrictive in terms of what they will share with outsiders. And so some of what these transparency requirements can do is actually tell us, how much should we be concerned about content moderation online? Is this a real problem that is diluting discourse, or is this just another version of the panic over the introduction of the telephone or the telegram? And we see it's not actually changing our discourse and our beliefs as much as we thought. So the transparency requirements are kind of central, not just because they're helpful to users, but because they can tell us whether or not regulation is something that might be beneficial as well.
That's an excellent point. Thank you, Stephanie. That was great. And so back to you, Abby, involved in many class actions on behalf of individuals with cases in this area, as well as you described to us representing governmental clients. What do you see as the next big issue or the next big concern from your viewpoint?
So I also won't be surprised if the U.S. Supreme Court takes these Social Media Censorship Act cases. And I agree that the future is in efforts to get disclosures. The social media companies are going to fight it tooth and nail, trade secret and everything else. The other thing I think that you're going to see increasingly, probably the more clever thing in the toolbox of state legislators and maybe the federal level too, is putting more teeth in deceptive and unfair trade practices and consumer protection statutes, and even you might start seeing some really clever lawyers craft some breach of contract claims against social media companies. But that sort of civil litigation by private individuals who say, for example, your policies say you're only going to kick people off who use, threats of violence. Well, you didn't kick off, I mean, that's one of the arguments that former President Trump made, like they didn't kick off all these people who made these threats, but they kicked me off. That sort of like the question then becomes that's not a very good argument for his case about the First Amendment applying to them, but that might be a better argument if you have good facts for those sort of consumer protection statutes. If you're basically being sold something deceptive, then again you have to prove that you were injured and that it's not just the public as a whole, because other people were kicked off. You were and they weren't, like what exactly is the harm there? So I think you might see more civil litigation with creative lawyers coming up with cases like that. I do think there'll probably be some revisions to 230. I doubt it'll be repealed. I don't think it's unconstitutional as currently written, but I do think that it'll get tweaked over time, and they'll probably start getting regulated a little bit more like common carriers. Up to that point where we're talking about regulating the basically acting like a publisher, that line between we're providing a service and that can be regulated, or we're making representations that cannot be deceptive, or we're entering a contract and we give you our terms of service and we're not supposed to breach that contract. The line between that aspect of their business and the aspect of their business that looks more like traditional newspapers picking, which op-eds to post. That's the devil's in the detail there with those nuances, I think.
Great, good point. Okay, Jesse, you've been waiting and listening to your colleagues and fellow panelists. Your reaction and your thoughts on what lies ahead for us.
Sure. Well, great comments from everybody, very insightful. And I appreciate, again, being able to be a part of this. I think I'll comment on really the two themes we heard. So first, the of sort of current litigation and potential legislation. So one is, I wanted to talk a little bit about the Second Circuit case, the blocking, the issue of public officials blocking. And, I was around the Twitter blocking case at the time it was litigated, and at the Justice Department at the time. And looking back on it, now a few years out, I look back at the Second Circuit opinion, and I have to say, thinking about the future and where courts will go, I think the opinion is somewhat flimsy in its analysis, and it doesn't really wrestle with all of the questions. And so I'll just give you two examples of what I think if courts are going to really deal with this question, they have to answer. So for one, the Second Circuit panel decision did not seriously engage with the nature of Twitter and how its parameters fit within the case law of how a forum becomes public. So Twitter is not public property. This is the point that that Twitter itself and NetChoice makes in these other cases now, which is that they have their own rights. They create the rules of their platform. It's private property, and its owner has established certain rules of engagement. The Second Circuit, in footnote 2 of the opinion, if you want to look at it, they say use of the platform is governed by terms of service which users agree to when they use the platform. And a Twitter user cannot choose to have an account that has a subset of these features. For example, a user cannot obtain from Twitter an account that prohibits certain other users from blocking them. Yet, just such an account is exactly what some users, the plaintiffs in that case, obtained from Twitter via a federal court injunction that the Second Circuit upheld. So the Second Circuit's opinion is at war with itself. It says, you can't get this account from Twitter, but we'll give it to you via an injunction because we're going to call it a public forum. They just didn't analyze how those factors affect the forum analysis. Secondly, I think the Second Circuit failed to seriously analyze how its holding should apply in other areas. So the court found that because the president used his private Twitter account as, quote, a channel for communicating and interacting with the public about his administration, he cannot engage in any viewpoint discrimination. Well, that sounds fine as far as it goes, but if that's true, then when the president holds a press conference in the White House briefing room or on the South Lawn of the White House, is he permitted to pick and choose which reporters he calls on based on his feelings about the reporters' viewpoints? Or, as the government pointed out in its petition for rehearing, if the president holds a rally or a press conference on private property, is he not permitted to invite some people and exclude others? The logic of the Second Circuit opinion is no, that these are, because the president is communicating with the public and allowing some people to comment, that this now has to be an open forum. So I think the question of what kind of forum you have when a public official goes on private property, which is what Twitter and Facebook insist that they are, they're not common carriers, they're not any of these things, that's what they say. Well, how can it also be a public forum? And that issue, no court has really grappled with it yet, and I've not heard anyone really, run that to ground and say, well, here's how you reconcile that. And then quickly, I'll just comment on the Section 230. I find that issue very difficult. It is extremely difficult to balance the First Amendment rights of the companies, of the users. But I'll say two things about it. One, some of the fight, I completely agree with Judge Branick that this was made before any of this was even a glimmer in anyone's eye. And so, it is time to have a public debate and have Congress do its job, which it never does, and actually legislate and figure something out. And maybe you have a middle ground where you can have some content regulation, like for obscenity and pornography and bullying and human trafficking and these things where you're protected. But if you decide to do what an editorial page does, which is be an editor of Viewpoints, then you're going to face the same thing the New York Times does, which is you're choosing among viewpoints. If you allow defamatory things to be said, you've got to answer for that. But my broader view is on social media and internet stuff, wait 5 years, wait 10 years, because the landscape is going to be so different. I just think 10 years ago, Twitter was not a big deal. 2012, it was around, but it didn't have any, and some of this will just, technology will overtake, and also trends. Even today, as I understand it, I guess I'm an old social media user now. Facebook among the younger generation, it's odd to say that, but that has been displaced by TikTok and others. And so, yes, it's incredibly powerful now, but will it go the way of MySpace in 5 years? We just don't know. And so some of this stuff, so I actually think I'll do one contrary prediction. I think these social media law cases will not be taken up by the Supreme Court in the near future. Just for fun, I'll throw that prediction out. We can all revisit this in a few years and see. But I think the rapid pace of change actually may make it difficult to get some of these more nuanced laws up to the Supreme Court because of the pace of technological change. Anyway, great panel, and I appreciate the chance to react to some of that.
Thank you, Jesse. And I'd like to say that'll be the topic for our third hour, which will start in 5 minutes. But I can't. I want to give Justice Browning a final word to make sure we hear from every panelist at least twice here.
Thank you, General. Well, first of all, I think I personally hope, and I know there are a lot of legal academics hoping with me, that Section 230 is amended at some point, just from a standpoint of updating it. I think that there's going to be federal action needed, and I say this in part because of the fact that we've got so many state legislatures weighing or taking action, and some of it is addressing, so-called content moderation limitations or viewpoint discrimination, whatever term you want to put on it. But I think we're going to need federal action, action at the federal level, because we can't have a state by state internet. Okay, we can't have 50 different state laws on content moderation. We take the area of data privacy, for example. You know, we have a patchwork quilt in this country of data privacy laws, and you know, you can't expect a tech company that's operating on the internet to have to worry about 50 different sets of state laws when it comes to content moderation. It's just not practical. Very quickly, I think we're definitely going to see this common carrier argument, which I think a lot of folks are dismissive of. I certainly don't agree with it, but I don't think we can afford to be so prone to dismissing it out of hand, because it's going to remain a tool in the legislators' toolbox. And if you have any doubts whatsoever about how receptive the Supreme Court may be, consider this line from Justice Thomas's solo opinion from before. There is a fair argument that some digital platforms are sufficiently akin to common carriers or places of accommodation to be regulated in this manner. Boom, he just put it right out there. Finally, because I didn't really get to address the blocking critics on Twitter, it's a subject I've been involved with both as a practitioner and as an academic, writing about this issue. One quick point I just want to make for the audience. We've obviously heard about the high profile cases like you know, the Second Amendment, Second Circuit decision involving former President Trump. But it's important to remember that blocking of critics and you know, censoring critics on social media by an elected official is something that takes place on both sides of the aisle, folks. You know, Alexandria Ocasio-Cortez has been sued for blocking critics on Twitter. So was President Trump. It occurs at all levels of government. You know, one of the more high-profile cases was a Loudoun County, Virginia member of the Board of Supervisors, a county official. You know, this happens at the lowest levels. It happens clearly at the highest levels, but it happens all around. And I think certainly one of the problems that courts are going to continue to wrestle with, as has been mentioned, is this blurring of the lines between a public use of a private Twitter account. And perhaps we have, you know, President Trump to blame for that because of the account he had as a private citizen, a candidate before he entered office, and the extent to which it is used for a public purpose. That blurring of lines is going to continue to be an issue that courts are going to have to wrestle with, and to apply what sometimes are going to amount to contradictory results. So I'll just put that out there, and again add my thanks to my fellow panelists and General McDaniel and certainly everyone with the Cooley Law Review for a wonderful, stimulating symposium.
Thank you, Justice Browning. And so I'm going to recommend to the Law Review, our next symposium will be entitled Social Media and the Commerce Clause instead of the First Amendment. Take that argument forward. I want to thank everyone. Our time is up. I do have one question from a colleague and professor. If the panelists will be inclined to have a question from the audience, I'd like to take it again. But before I do so, because I know we will lose some of our audience because we're at our starting or ending point, I want to thank all the panelists again. This was fantastic. I learned a lot. The time flew by. It was very engaging. My thanks to the Law Review for picking such an incredible slate of panelists, as well as my thanks to the panelists for attending and giving us their thoughts today.